Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
Hi, everybody. This is not Emmy-winning broadcaster Joel Waldman, as I'm sure you can see. I'm Jo Potuto, law professor Joe, and I'm going to be commenting on the hearing today. As you know, Judge Everett is pretty much always on time. I'm going to try to give you a little bit of a sort of a heads up as to what's coming, but I'll stop as soon as the hearing starts. The motions, there should be two motions heard today. And the docket said that this is scheduled for 30 minutes. We'll see. One of the motions for sure is a motion in limine. The defense wants to be able to refer to Luis Rivera as a member of the Latin Kings gang and as a leader of the Latin Kings gang. And I think the discussion there is going to be pretty straightforward. And you all know this case, so I think you're going to be able to follow the hearing in any event. The second motion, I'm guessing, because I'm not sure, is going to be a motion for discovery in the case. And this one's going to be more convoluted, in part because I'm not sure the defense is going to be able to articulate it as clearly as they could or should. It relates to phone extractions of phones, and the phones are Wendy's from 2014, Harvey's from the episode in October when a new investigation started, two of Donna's, and the one really at issue here is going to be the phone that was confiscated from her at the airport when she was arrested, and also iCloud data from Charlie. The issue, although as I say, I'm not sure it's going to be articulated as clearly as it probably should be, is Donna's phone that was confiscated and raw data extracted from the phone. What the defense got was the Cellbrite records that the prosecution had. What the defense wants is the raw data, and the difference is the raw data is everything that you can get off the phone. It would be metadata. It might be deleted emails. It could be anything. It could be apps. It could be anything. Cellbrite organizes and it will relate to what the request is. So if the state says, give us everything between Donna and Wendi, then the Cellbrite records will only be those records that relate to that subject. The defense is claiming and will claim that it asked for the raw data and it didn't get the raw data. It only got the Cellbrite records, and it, in its brief, is accusing the state of holding back. What appears to have happened is that the request wasn't made clearly enough. The state thought it was complying. It wasn't complying. I see that Judge Everett is now on the bench. It looks like he's ready to go. But in any event, that's the crux of the issue here. The state has agreed to give them everything that they have that they didn't get with regard to the other four items. That's the iCloud.
Afternoon in State versus Donna Adelson, 2023 CF 3226. Two motions we're here for this afternoon would be the defense's motion to compel and also the defense's motion to extend previously ordered deadlines for witnesses, exhibits, and pretrial motions in completing discovery. Part of the reason I believe we need to have a hearing on these matters as well, and I'll let you make your argument in just a moment, Mr. Zellman. Have you discussed with your client specifically as it relates to the raw data that you are seeking, specifically for Charles Adelson and herself, that this has the potential to reopening the door of the conflict?
Your Honor, I don't think that it would. It's in the same category as the emails that Your Honor authorized us to obtain in April, the raw, unredacted, unfiltered emails from our client's own account.
While they're certainly discoverable and while you have an interest in using them to prepare for, the question remains, have you discussed with your client the possibility of this reopening the door to any conflicts?
No, we have not, because I don't think that it would reopen the door.
Very well. You may make your argument.
So, Your Honor, you may recall a number of times we've been before the court and the defense, and as laid out in the motion to compel, we have been asking for the raw, unredacted downloads, the emails, and we were repeatedly told that that had been provided to us. When we were able to retain an independent forensic data expert and provided them with the materials that we had been provided, we were informed that those are not the raw forensic extractions. And I was asked to obtain the raw forensic extractions. And in the motion to compel, I actually cut and paste the expert's explanation. I'm not going to try to paraphrase it. It's an explanation that he provided as to why it is his recommendation that we obtain the raw forensic extractions. That's what I did. I've requested that. It's taken, we're now at a month since I made that further request, and I believe that we're entitled to that. I think the rule provides that, and our intent in part is to verify the cell brights that the state has prepared. The only way to do that, according to our expert, is to obtain the raw extractions from the state. And that's why we're asking for that, Your Honor.
Mr. Kappelman, you may respond.
No objection, Your Honor. I would just ask that whatever reports are generated by their expert as a result of that data being re-cell-brighted be provided to my office in a timely manner, because I'm advised, based on the version of the program and type of program they use to produce a report to verify our report, there could be some small differences involved. So I would like to not be surprised with that at trial.
Well, as to that, I will grant the defense's motion to compel. As to the issue of the conflict, specifically, Mr. Zellman, in part, when we had the first case management, I had counsel verify that they had no conflict as far as giving conflict-free representation to Mrs. Adelson. Should anything change with your review of these cell brights that may include communications from prior counsel or deal with matters that pertain to information that was provided by Charles Adelson, at that point, we are going to have to revisit the issue. Does everyone understand those?
Yes, sir. May I approach with a proposed order?
You may.
This is just the same one that I sent. Dave, you're copy.
As I said, the issue is Donna's phone that was confiscated.
Okay.
The state had said they thought that there were communications between Daniel Roshbaum and Donna.
Mr. Corbett and the defense expert have been communicating over the last 18 hours or so that once that order was signed, Sergeant Corbett was going to upload that to a portal that they've already tested this morning, so that our expert can download it. That'll be the fastest way for them to do that. He said as soon as Sergeant Corbett indicated that as soon as he was given instructions to start the process, he would do so.
Right. As to the second motion, the extending of all deadlines for the defense. In particular, we've already had two extensions that have been provided by the court, first from the April 30th deadline, second from the May deadline. Does the defense have any motions that are unrelated to the new discovery?
No, Your Honor.
All right. As to the motions that you believe you still need to file that are in some way related to this discovery, what is preventing these motions from being filed and you seeking leave to amend as necessary?
Your Honor, due to scheduling, we were only able to depose Mr. Newland and Sergeant Corbett Wednesday, Thursday. We are deposing Special Agent Pat Sanford, I believe, on this coming Tuesday. Before filing those motions, I think it's appropriate to make sure that there's a good faith basis to do so. And having those depositions, that testimony, in my opinion, it's necessary before we do that.
Right. And I believe there are some other depositions that are scheduled for July or I believe next week as well.
Yes, sir. We have one meeting as well, maybe Tuesday and Thursday.
Part of the reason that we have, whether it be discovery or any sort of deadline cutoffs in any case, is not simply arbitrary of the judge just saying, get it done by a certain date. It is so we can proceed orderly to trial. I believe your proposed dates were to be within 4 weeks of when you believe the state has fulfilled its obligation. That's when you would want to file your motions.
Well, Your Honor, given that we filed these on June 27th, we're obviously 2 weeks past that.
Oh, yes, we are.
And it's certainly not our intent to do anything to delay the commencement of the trial as scheduled.
The proposed date of when this would occur is not specific. It's not certain. It's pretty much a moving piece of jello. Is there anything that you can do to convince me that it's otherwise going to be a specific date in what you're asking to do with filing these motions several weeks after you believe the state has complied?
Unfortunately, it has been a moving target because we have not received all of the discovery from the state. During the depositions, during yesterday's deposition, we learned that he had conducted call frequency analysis between Donna Adelson and Charlie Adelson for a longer period of time than that had been previously disclosed. He is going to send us that if he had completed a report. He's also sending us the PDFs of the actual call frequency analysis that is contained in the demonstrative, because those are just excerpts of the call frequency analysis. So he's going to be sending us the completed call frequency analysis. So I say that to demonstrate that it is difficult for the defense to file any appropriate motions or to provide appropriate responsive either demonstratives or exhibits when we still have not received everything from the state.
Same time to file, and how many motions are we talking about at this point?
Potentially 3, Your Honor.
As to these 3 motions, would any of them affect the ability to actually move forward with the trial on August 19th?
No, I don't believe so. None of them are just positive.
Very well. Do you have any further argument in support of your motion?
No, Your Honor.
Ms. Kappelman.
No objection, Your Honor. We've just asked that we be given the same grace. I'm aware of at least 1 or 2 more things that the state intends to do that could, need to be done past the deadline. So all indications are that both sides are working diligently to get this done. I understand your comment about the Jell-O, and I've got a couple orders myself of Jell-O that I'm wrangling. So I'm trying to minimize it, but things do come up past the deadline. So we're going to have to work
Ms.
through those
Kappelman
things.
specifically asked these emails, which has contributed to this. What is it else that you believe is going to come up on the state's behalf?
The emails?
I said, other than the emails,
Oh,
what do you
What do
think
I
is going
think's
to
gonna
come up
come
on the
up?
state's
There's a
behalf?
defense witness that's been listed that the state has discussed trying to depose and may try to get that done before the deadline. There's a handwriting expert that the defense is aware of, that a handwriting expert exists, but they haven't been given the name or the report yet. I don't have the report yet. So that's something that's pending that would be in violation of Your Honor's order. So there are a couple outstanding issues that I'm aware of. I was not aware of the issue that the defense just brought up regarding Corbett having done a report, but he does do work to generate the slides that were prepared and discovered by the discovery deadline. When asked about how did you come to those conclusions in deposition, he's going to say, I looked at the data. Well, they want to see that data. Okay, we don't object to that, but I don't think that's the same thing as a discovery violation.
Final pretrial hearing is August 8th. As to the date of when all motions need to be filed, so we can have a meaningful hearing on August 8th and proceed to an orderly trial on the merits. These motions are going to need to be filed by July 21st. Any motion that is not filed by either the state or the defense by that date, the issues are subject to being deemed as waived. If you need to seek leave to amend as to the specific motions that will be filed on this date, you may certainly do so. However, again, this is not just arbitrary date making to throw something out. If we are going to in fact have a trial on the merits that will be orderly, both parties needed to see what you intend to raise as pretrial legal issues that the court needs to rule upon. There's not going to be a trial by surprise either for the state or for the defense. Am I making myself clear?
Yes, Your Honor.
Yes, Your Honor.
Will you state those dates one more time? Motions to be filed by July 21st and
21st.
final motion hearings on August 8th. Is that correct?
The final pretrial hearing is on August 8th. This time has already been set apart by a previous order. As to the motions in limine that have been filed, I believe the defense has renewed its motion concerning the Latin Kings. Is that correct?
Yes, Your Honor.
The state filed any motion in limine by the previous deadline.
We renewed motions that were filed previously. There's nothing new.
Well, as previously ordered, copies of all of these motions, when they are filed, they need to be served upon the court. Please do so if you've not already done that regarding what has already been filed. I believe the next date that we will have, unless there are other issues that need to be addressed, will be August 8th. Does either party have anything it needs to raise?
Nothing from the state, Your Honor.
Can I have a moment, Your Honor?
Go ahead.
So Judge Everett intends for this trial to be on August 19th. That's very clear. And they have not discussed the motion in limine with regard to Latin Kings and Luis Rivera. And as you heard, Judge Everett also is very concerned about the potential conflict issue.
We are in recess for this afternoon.
Thank you, Your Honor.
Okay, short and sweet here. I will stay on for a while to take any questions or if you have any comments about what went on. Let me just add to what happened with regard to the extraction of data from the phones and any data from the iCloud with regard to Charlie Adelson. The issue with regard to Wendy's phone obviously is there anything, not Wendy, sorry, Donna's Donna's phone from the arrest. The issue obviously is there anything in those, in the data extraction that will refer to conversations that Donna had with Dan Rashbaum, or that implicate in any way the conflict issue that led to Daniel Rashbaum to withdraw, and led to the appointment of new counsel. The worry that the state had and why they requested that that the defense employ a conflict team to go through the raw data and confirm that there was nothing in there that raised a conflict issue. That's what the state wanted. And that's what the state had in an email exchange conveyed to the defense. The issue is if there's anything in there, then the risk that this team, this new defense team, will be conflicted out raises its head. And that's why Judge Everett said, if you see anything that suggests that, stop immediately, come back to court, and then we'll have to look at it. I'm a little surprised that he just didn't order them to use a conflict team to go through it and confirm, because at least with regard to the material prior to today, the state was saying that they thought there were some items in that raw data that would raise the conflict issue. Now, it may be that since then they have looked more and they have decided that's not true. Otherwise, it seems to me to be a little risky here to be doing this again. But it seems as though the defense is pretty certain there won't be anything in there. And they've talked to Donna, so I assume that's where they're getting their certainty. And the state didn't oppose today. So that's where we are. On the Luis Rivera issue, they didn't push it today. So I don't know. It looks like we're going to be where we were with regard to that, unless they raise it later, before the last hearing, which he said will be on August 8th. And that issue was the state did not want the defense to be able to refer to Luis Rivera as a member or leader of the Latin Kings. They said it was character evidence. The defense said yes, but it relates to Donna's fear and why she acted the way she acted. That struck me, frankly, as pretty strange, because according to Charlie's testimony at the trial, he didn't know Luis Rivera was was one of the people that drove up to Tallahassee the day of the murder and was participated in the murder of Dan Markel. He didn't know that until after the bump when Katie told him about it. So it's a little peculiar that the defense was claiming that she was afraid of this because of Luis Rivera being part of the Latin Kings, because her behavior from the time of the bump forward was before she would have known that, at least for a period of time before she would have known it. But anyway, that was what that other motion was about. So let me see if I can find some questions in here. One of the questions was Beach Girl 321, and I answered that. And of course, the judge made it clear he plans to have this trial go on August 19th. There was another question. I apologize. I noted the question. I didn't note from whom the question came, and it was whether the state will be able to tell the jury that Donna is a co-conspirator with Charlie and with whoever else may be prosecuted in the murder. And the answer to that is yes, and it's inevitable. There's no way they're going to be able to go forward with this trial without that information getting to the jury. So if you've got other questions, and if you've put them in before, it would help me if you put them in again. Let me see. Does Joe have a desire to jump back into trial work or to provide consultation to a team on a live trial? I always am very curious. I always think I have a point of view. I always think it's worthwhile. And I may be wrong on the last one, the first one, that I'm always curious. And I always think I have a point of view, obviously. There's no way those are just facts. Whether I could be helpful is probably less likely, but I do like to be involved. So that would be my answer to that. But Let me see if I'm trying to go back through. If you had one and you could just redo it, it would help. Oh, here we go. This is from Arctos. Could you clarify the conditions of Wendy's testifying? Or was it that she can't be charged for anything? And I lost the question, but I got enough of it to know. Wendi was given what's known as use immunity. And what that means is, well, let me back up a little. Wendi has a privilege against self-incrimination. And the Constitution says you cannot be forced to provide information that would help the state to prosecute you for a crime, period. And you can, and if it looks like that might occur, you can raise the Fifth Amendment privilege saying, I don't have to answer this question. I won't answer this question because it might tend to incriminate me. That's where Wendi was. In order then to force her to testify for the state, she has to be given immunity from prosecution for anything she might say, at least anything that she says that the state couldn't have gotten in another way. So in other words, if she said, I was at our house on the day of the murder, and that's the only way the state could know that she was at the house, they can't use it. But if the state can, and of course the state can, first they have that information from her prior to her being compelled to testify, that first interview that she did the day of the murder, where she talked about it. That wasn't compelled by the state because it happened before the state said, we want you to testify at trial. That's okay. Anything that they could find another way. So if someone else said, we saw Wendy's car at the house that day, that's okay. The only thing that can't come in is something that the state gets directly from her that might tend to incriminate her, and anything that they got only because they compelled her to provide the information in the first place. So if she said, I was at the house on the day of the murder, and the state had no way of knowing that other than Wendi saying it, then they can't go out and interview the neighbors and say, did you happen to see Wendi Adelson the day of the murder? Because the only reason why they're asking those questions is because she said she was there. They can't use the fact that she said it, and they can't derive evidence from the fact that she said it. But if they can get it in, if they got it another way, or it came from her, but before she was compelled to provide information, all that is completely open to be used by the state in a prosecution. So I hope that was clear. If it wasn't clear, just ask me the question again, and I'll try to do it again. Let me see if I can get back to questions here. If a defendant put their attorney's names in all of the email texts, would that keep the prosecution from being able to use those emails texts? No. The attorney-client privilege applies to private communications. So I'm assuming from your question that the texts were going to other people in addition to the lawyer. And if that's true, there would be no lawyer-client privilege, which would cover it because they wouldn't be private communications anymore. Okay, let me see if there's anything else. I don't want to hold people up as I look through these questions. Okay, this is from Jane Kreisman. Will George approve that Wendi was lying and cancel out her immunity? I don't know whether George is going to be able to do it, but if she does, it will cancel out the immunity, because you get the grant of immunity on the promise that you will provide the information and testify truthfully. So you can't get a grant of immunity and then go on the stand and lie. You can't get a grant of immunity and then refuse to answer the questions. So neither of those things will protect you then from the state being able to use the information. The other thing is, and I've talked about this before, there's something called an immunity bath. So you get the grant of immunity and you say, aha, this is good. I've got all these other crimes I did. I'm going to get myself a complete, bath, and they're not going to be able to use anything. So the state asks the questions such as, were you at the gym at 10 o'clock in the morning of February 5? and you say, yes, and when I was at the gym, I committed 3 murders, and I also thought about these murders that I committed last year. Those answers will be admissible against you in a prosecution because you went well beyond the scope of the question that was asked. So you're not entitled, because you have immunity, to answer things that were not asked to give yourself a bigger umbrella immunity there. So you have to answer truthfully. You have to answer, and you can't just use the opportunity to talk about other things not related to the question asked in anticipation that you can cover yourself and now you can't be prosecuted for anything. So that's the way the immunity works. And and the issue whether what the immunity covers, whether the state found information another way, whether your answer went well beyond the scope of the question, all those can be subject to argument, and the judge would have to decide them. Okay. This is from Dr. Reinhardt. Do I think Donna is the godfather or godmother of this terrible crime? I think the answer, my view of it is yes. She was at least behind pushing it. I think she was certainly the person that got Charlie involved. I'm not sure that Wendi on her own would have initiated. I think Wendi is more, this is my view, and I'm not a psychiatrist or psychologist. Wendi strikes me more of a passive aggressive. She wouldn't on her own initiate, but she would be able to instigate others to initiate on her behalf. The most likely person there is Donna. Potentially Harvey, but on the evidence we have so far, it looks like Donna. Let me see. Is there anything else before we? Okay. Why? This is RC. Why is the money that Dan owed Wendi for their house not mentioned as a motive? Well, the money that Dan owed Wendi for the house, and I'm not quite sure what you're referring to. Oh, Daniel Rashbaum Wendi for the house is a motive. I don't know. It may be that the state doesn't feel it needs that information. It may be that if they're thinking about a prosecution of Wendi, they want to hold it back. It seems to me they have enough evidence here, and they've certainly got enough evidence of motive, and motive is not required in a criminal case anyway, that they wouldn't go out and add more here as compare and give the defense a chance to think about it and respond rather than reserve it for the next trial. Let me see if there's anything else. Okay, this is from Julia Adenurse. At what times does the state just let them open themselves up to the conflict instead of constantly advising them? Well, the problem is, and that's part of the reason why the judge asked if Donna had been advised that there's a potential conflict there. Defendants, by and large, can waive anything. It may not be smart for them to waive, but they can, by and large, waive anything. Conflicts of interest with attorneys is a different category, and an occasion in that category, it's not waivable. And if there's really a conflict that infected the ability of a defendant to have a fair trial, it may be something that the defense, well, maybe something the defense can't waive, and therefore the conflict is going to reign supreme. And that's why the state, part of the reason why I think the state is being careful. The other reason is, I mean, once you've gotten once burned, you don't want to go and get burned again in this. And the state is pushing to be as careful as possible now because they don't want any risk that you're going to end up with this trial not going, or this trial going and then a reversal on appeal because Donna didn't have effective assistance of counsel. The last thing anybody wants is to have that happen. I don't even think Donna would want that to have that happen. I'm getting a question here. Did I attend Rutgers Law School? Yes. Live in a third-floor apartment in West Orange? Yes. But I don't know who Jay Weinstein is or why Jay Weinstein would know that. But the answers are yes. Text me or email me privately and let me know. Okay. I don't see anything else unless somebody puts something up at the end, because I don't want to keep people. I mean, I know people can just, you can just sign off when you want, but I'm sensitive to it. Here's one from Roxanne that is at the end. If they find communication between Rashban and Donna, will the attorneys have to recuse? If they see the communication and stop immediately, there's a fair likelihood they won't have to recuse, which is why the judge said if you see anything that suggests anything, stop and alert the court. It's going to be subject to an argument about it. There may be a hearing on it about, did you read beyond the fact that it's that you could see that the text or the phone call was from Daniel Rashbaum, or did you stop right then? But if they did stop right then, it doesn't necessarily mean that you've got a conflict that you can't fix. All right. I don't know that I see anything else here. Oh, here's one. I'll do one more and then we'll end. And this is from Barbara. What did you think about Donna's excuse about a non-extradition country? The one that she testified to at the hearing a couple of months ago, I thought was just silly. And for those of you who don't know or didn't see that hearing, she said the reason why they were going to Vietnam was everything was so stressful. They needed a break, and they went to Vietnam because they wanted to go somewhere where they'd be able to get back quickly, and there wouldn't be a lot of red tape. I just thought the explanation silly. I guess silly is about as good as I can do. It was a silly explanation, and I think it's going to come back to bite her in the butt, frankly, because she's now under oath again, giving a silly explanation. When she gets on the stand, and I think she's going to have to testify at the trial, the state is going to be able to cross-examine her on this silly explanation. So that's what I think is coming. I said I would end now. I'm still getting questions here. I don't want to stop anybody, but I don't want to hold up anymore either. Let me stop here because, and I apologize to anybody who had a question you really wanted answered. Maybe at another time when I'm doing this, hopefully I'll be doing more of this. You can get it in. I think this is probably a good time to stop. It was a quick hearing. It was a hearing in which Judge Everett made clear that he's not playing games anymore. Not that he was, malleable before, but he certainly came across this time as being very stern, no smiles, no jokes, no let's be friendly. It's all let's get to business so we can get this trial done. I enjoyed doing this. This is the first time I've hosted independently, and I just hope that I did it in a way that was okay with all of you. So thanks and goodbye. I hope you have a really good week and weekend, and I hope it's not hot wherever you are. So long.